May it please the court. My name is Kimberly Sharp and I represent the defendants in this case. This case is what I believe very simple. It's a case about delivery of a deed, almost like a law school problem. My client got a deed and put it in her closet for 8 years and didn't record it. However, she did record it before any other interest came in. In this case, there's actual versus constructive delivery. So the court found that the decedent did not have intent to deliver the deed. The new girlfriend of the decedent came in and claimed 10 years later that when he handed the deed, when the decedent, Mr. Shestag, handed the deed to my client in 1999, that he did not intend to deliver the deed to her. They use cases mostly that are constructive delivery cases for the law. And if you look at constructive delivery, if there's one case where there was a tin box and there's an old man who's on his deathbed and he says, go to the tin box, that is when you look at intent. You're looking at the intent of, did he intend to relinquish dominion and control over the deed instrument? What happened at the trial court is at trial, the plaintiff introduced evidence of the use of the property post-delivery as evidence that the decedent did not have the intent to deliver the deed back in 1999. Use of the property is a lot different than giving up relinquishment and control of the deed. And if you look at the cases, they talk about relinquishment of the deed instrument itself. So quite simply here, it is undisputed that Mr. Shestag gave up, he relinquished control of that deed instrument to Ms. Robertson back in 1999. She took it home. They didn't live together at the time. She put it in her closet. He gave up the locus poenitentii on that document. The plaintiff argues that he didn't give up dominion and control of the property. He collected some rents, although there were disputes on how much was actually cashed, and that he filed a homestead action, claim of homestead. He was attempting to defraud creditors. The tax collector came back later and said that his claim of homestead was fraudulent, but the court nevertheless relied on that, his claim of homestead, as his intent that he was the owner of that property. We went to trial with a presumption. Actually, if the grantee has possession of the deed instrument, there's a presumption that that deed was actually delivered.
The only thing, the deed was not the only thing that was created at the time the deed was delivered. Is that correct?
Correct. There was a will as well.
And the will purports to devise the same property that is the subject of the deed.
The will makes a reference, but when you look at the deed instrument,
Well, it seems to me to be more than a reference. I hereby bequeath those certain and various assets, and then it includes the property that's described in the deed.
Mr. Shestag, and this was very clear in the evidence, wanted to make sure that his sister never, ever got any of his property. He was very clear about that.
And he may have done it right, he may have done it wrong, and that's what this case is about. But this will seems to be capable of being read as saying, I own some property and I'm leaving it to you when I die.
If you look at the Berry case, Your Honor, which is the second DCA case here, the former wife in that case, there was a case where a father gave a deed to a husband, his son, and his wife, and the wife challenged that later and said, well, I didn't intend to convey that. I didn't know what I was doing. And the court said that the parties to a written instrument have a duty to learn and understand the contents of the instrument before signing it, and as such, she is bound by the deed. Thus, the fact that she and the former husband executed documents during their marriage reflecting an ownership interest in the property does not defeat Mr. Berry Sr.'s ownership of the property because he held a deed conveying it to him. There was also another case where there was a will and a deed delivered at the same time, and that's the Paramore case, which is actually cited by the trial court in the order, and that case actually supports my client's argument, even though it was cited in the order finding in favor of the plaintiff. In that case, it was a man who put deeds to his children along with a will in a safe deposit box and instructed his children to pick them up upon his death. He was trying to do something that took effect on his death. He never actually handed them to the children during his lifetime. We actually have that here. Mr. Shestag, it's undisputed, handed the deed to Ms. Robertson. So it goes on to say that the clearest delivery is by a manual tradition of the prepared deed with accompanying words or circumstances showing an appropriate intent, which happened in this case. So, but a grantor may fully relinquish a deed signifying a conveyance otherwise than by placing it in the grantee's hands.
Is there a full relinquishment of interest if the quitclaim deed contains qualifying language such as in trust for?
Yes, because, and I cited cases in my reply brief, that when you give someone a deed that's in trust for, it is you're giving them a present interest to future enjoyment. So once you relinquish that deed, you can't undo the trust. And I cited cases because
when you say undo the trust, does that create a trust in and of itself, or does that incorporate another document to be made in the future?
No, it creates a trust in and of itself, and I cited some trust cases with the elements of that because he wrote in trust for, and this is how he had gotten the property from his mom when his mom gave it to him because the mom didn't want the sister to get it either. And I actually had the plaintiff admit during the trial that John Shestag had told her that his mom did this because she didn't want the sister to ever get the property, and the plaintiff actually admitted that at trial, which is in the record.
Terrible sister.
Apparently, and his fears were actually valid because she did end up contesting the will later during some of the probate proceedings that the plaintiff went through, and that was his fear at the time when he told Ms. Robertson, he gave her the deed, and he explained it, and I had included some of the language in my brief because I thought it was important from the trial. He said, a deed can't be contested, a will can. And he explained that because he had been through this with an elderly gentleman that he was helping, and he liked to, Mr. Shestag, it was an interesting character, I think everyone would agree, but he liked to play lawyer, and he drafted all of these documents himself. You could see he did it back in 1983 for his mom. I think he had some paralegal training or something.
This is Arizona, right?
I'm sorry?
This is in Arizona.
Yes, it's in Arizona.
Yeah.
So, but getting back to the trust, he did create the trust through that document. It said in trust for, and once he delivered it, that's final. It's irrevocable. And I cited that language because at first I saw the statute, and the statute says that you can revoke a trust unless it's in there, and then I saw that it says it does not apply to anything prior to the statute, which back in 1999 it didn't. And if you look at the common law, which I cited in there,
Just the opposite.
I'm sorry?
Just the opposite.
It was just the opposite, that unless the instrument says that you're reserving the right to revoke the trust, then it's irrevocable. So when he took the paper and he handed it to her, it's irrevocable. She took it home. So I think some of the confusion is in that locus poenitentii word, where they're trying to say that he didn't give up dominion and control of the property because he continued to use it. That's not the issue here. The issue in all the cases, if you read them carefully, talk about the deed and the deed instrument and whether he was giving up control of the deed instrument. And usually, like I said, it's in constructive cases where there's constructive delivery, and you have to look at the intent. If it was in a common safe and everybody had access to it, was his intent that he couldn't go and get that deed back? Was it his intent that when he gave it to someone, he couldn't call him up and get it back? There was one that I think they cited that was a case where he gave instructions to a lawyer. And yes, then in that case, if you give something to a lawyer and you say, don't record this, then the court does have to look at the intent and say, what was his intent in giving up relinquishment? Could he call up the lawyer and get it back?
What was the reason here why the deed wasn't recorded?
Miss Robertson put it in her, she brought it to the lawyer's office and said, I have this, I don't know what to do with it. And I think that was part of the testimony, was that, the lawyer told her, well, you need to record this. I don't know that she knew, and I think there was an issue.
She didn't do that till after he died.
Correct.
Was she aware of the will?
Yes, she had a copy of the will as well.
If the trial court believed that she didn't record it because she knew he could take it back, that she really wasn't going to get title until he died, and if the court believed that he in fact reserved the right to take it back or to otherwise dispose of it, this would be an affirmance.
None of the cases talk about, and I haven't seen any case where you physically deliver a deed and it talks about the person being able to get it back from the person they relinquished it to.
But even the Paramore case, which you argue supports your position, does have language that talks about what was the intent of the grantor and determining that intent. And if the intention is manifested by acts and declarations and it may consist of a transfer and so forth, the test of delivery of a conveyance is whether the grantor intended to reserve to himself the locus, and I won't try the Latin, and if he did, there is no delivery. If he parts with control or evinces an intention to do so and to pass it to the grantee, though he may retain custody or turn it over to another, then delivery is complete. So it's a very factually driven analysis.
In this case, Your Honor, in the Paramore case, the deeds weren't actually delivered, and the court says they were never handed over to them during Fred's lifetime. That's key.
What the court in Paramore did was affirm the trial court's determination of factual issues and then matters of law, applying the law to the facts.
Because
so
there was...
isn't the question here, is there substantial competent evidence that supports what the trial court did? And if there is that an affirmance?
No, there's not substantial competent evidence, because what the court, and if you look at the order that the court entered, the court relied on his claiming homestead and collecting rents as that he didn't have intent to release control of the property.
Those are two factors that suggest he was intending to retain control of the property.
Of the property, Your Honor.
You have a will that doesn't that attempts or purports to devise the property at the time of death.
The control of the property is a lot different than control of the deed, and I think his use of the property is entirely consistent with giving her a deed that says in trust for. He gets to use the property during his lifetime, and when he passes, she records a certificate of death and it goes to her. So that is consistent. And the language that Your Honor read, but if he parts with control of the deed, and then it talks about, or evinces an intention to do so by giving it to someone else to pass to the grantee, the delivery is complete. And then it says, the analysis is, it was under the circumstances, in that case in Paramore, equivalent to a manual delivery. We don't have to look at circumstances that equate to...
You agree that the law is, these things create a presumption?
Yes.
And a presumption can be upheld by the evidence or it can be overcome by the evidence?
Your Honor, we had a presumption that it was delivered. And I think I cited the James case, or the Jones case, again I'm confused, that said that you can, if there is actual delivery, then you can rebut that through fraud, mistake, or accident. That's fraud, like I say I'm going to do something in the future if you give me the deed with no intention and I have the deed. So therefore, yes, there's a presumption, since I have possession of the deed instrument, that that can be rebutted by saying, well, you defrauded me into getting that, or it was a mistake. You know, I had it stored in a box and I gave you the wrong box. That makes sense. There was actual delivery, but there's a way to rebut it.
It was a constructive delivery.
Correct.
And it's in that constructive delivery that the question of whether the grantor intends to take it back.
Correct.
I guess before the end of the constructive delivery process.
Correct. And in this case...
Whereas here, there was an actual delivery.
Correct.
And it's your assertion that Paramore suggests that once there's actual delivery, that's done. And the intent to take it back or whatever doesn't make any difference at that point. There was actual delivery.
Right. Correct. Once you hand someone a deed, I don't think you can go and say, well, tell the world that it's yours. And that actually happened in the Berry case. The court said, well, just because they signed documents claiming that the property was theirs wasn't evidence that they intended it to be theirs. But one thing I wanted to point out, Your Honor, on the presumption, we go in with the presumption that it was actually delivered. That actually is held up by undisputed evidence that it was actually delivered. No one is contesting that he did not hand her the deed instrument. We in discovery, actually, my client...
At that point, whether he intended to try to take it back or not then becomes superfluous.
Right. Back in 1990, when he handed it to her, he gave up control of the deed.
That's a done deal.
Right. But we
You're
actually...
right at your 5 minutes left, so do with them what you wish.
Okay, I was just going to say, one point was that we did cite his own words from 2004 where he wrote a letter to a tax collector because my client was paying all the taxes and he got one of the bills, and he wrote back and signed it. I deeded this property to my friend Diane Robertson years ago. So I think if the presumption that we already had was rebuttable, I don't think that there was clear and substantial evidence to undo his own words saying that he had actually deeded the property.
Thank you.
May it please the court, Raleigh Green on behalf of the appellee, Beverly Angelo. May I also reserve 2 minutes for counter rebuttal?
You don't have a cross appeal, do you?
Oh.
Then you don't get to do that.
All right, thank you, Your Honor. I believe with Ms. Sharp that delivery is the essential question at issue here. The critical issue in determining delivery of a deed is whether the grantor intended to reserve or relinquish the locus potentiae. I apologize if it's not pronounced correctly. Or it's really the...
I mean, I was really impressed by Ms. Sharp, but then again, I
I
have
was
no
too.
idea whether that was an accurate pronunciation or not.
And in other words, the ability to change your mind with control or ownership of the property.
And does it make any difference whether you're talking about actual delivery versus constructive?
I believe if you look at all of the case law, it's the intent to give up control and ownership of the property. The language doesn't say control of the physical deed. It's the actual control.
So even if there is a physical actual delivery of the deed, the court still, that somebody can still come back and question the intent behind that?
Yes, Your Honor.
So all the deeds that are recorded downtown could be questioned?
Well, I think in this situation, the deed wasn't recorded prior to death.
What I'm saying is I mean, I don't necessarily think recordation has anything to do with whether there was an intent to deliver the deed. Correct?
Correct. I do think the intent is a critical factor, and I think that's best reflected in the first TCA case, James v. Mabee. And James v. Mabee, who was the owner, deeded the property that he owned, 75% to a company named Work Enterprises and 25% to James. At that time, he handed physical delivery the deed to a representative of Work Enterprises with the last name Urquhart. Years went by. Urquhart did not record that deed for whatever reason. Mabee, as the owner, continued to lease out the property to a third party, held it out as his own, and the court eventually determined that there was no legal delivery, even though there was physical delivery. I believe the court cited, and this is very similar to our case, where the decedent also leased out the property to a third party. The court cited that with all of the evidence taken as a whole, are they to assume that if an individual is leasing out the property to a third party and the purported grantee is not taking any action, even though that they know the former grantor was taking this action, that they would infer that there was some type of instruction or at least understanding between the parties that this deed did not take a present effect, that it was not intended to convey a property. Whatever reason, James Mabee, Urquhart did not record the deed, did not take possession of the property. And I think under our situation in the instant case, where Ms. Robinson and Ms. Lascola, had physical possession of the deed, did not record it for 8 or 9 years, even though they recorded separate deeds that he handed them. I think it's also logical to infer that the trial court made the determination that John P. Shestag, as the grantor on the deed, did not intend to convey give away relinquish the locus potentiae of the property. And I believe there is substantial competent evidence on the record to support that ruling. Again, it's Appellant's argument that physical delivery is conclusive. And I think if you look at James Mabee, that case by itself contradicts that thought process. Again, if you look at the Supreme Court case Janes v. Janes, or the other first DCA case Paramore v. Paramore, physical delivery is discussed. And in James v. Janes, I believe James v. Janes was a situation where a husband had executed a deed to his wife and then put it into a safety deposit box that they both had access to. I believe in that case, the Supreme Court found that there was delivery because the wife had equal access, and it was a normal course where a husband would place something or where a couple would keep important documents. In that case, they determined that there was physical delivery, but the inquiry did not end there. They looked at the totality of all the circumstances to make the determination that, all right, there was physical delivery, but we need to look at these other factors. Once we determine all the factors surrounding the execution of the deed, then you make a determination as to the grantor's intent. And it's the intent concerning the property, not just physical control of the deed. I think at the trial level in this matter.
Do you agree with the appellant that the analysis is different if it is actual delivery of the deed versus constructive delivery of the deed?
I don't. I believe with physical delivery of the deed, with possession, it creates a presumption. But I believe that presumption can be rebutted by competent substantial evidence on the record.
Hasn't the presumption that's been discussed in this case, the presumption of delivery based on possession?
Yes, I believe that is the presumption.
That doesn't go to the question of the intent that you're asserting.
I don't believe
You're
there's...
saying is he delivered the deed, but he didn't really mean it.
Well, I think the presumption is a presumption of intent, which is rebutted. The fact that they have possession of the deed, I will acknowledge that that does give rise to the presumption. Likewise, I think recording of a deed prior to the grantor's death would have given rise to a presumption of intent, but it is not conclusive.
Well, as I have read the cases, they talk about presumption of delivery based on if I possess the deed, there is a presumption that it was delivered to me.
I think that's correct, yes, Your Honor.
Doesn't have anything to do with intent beyond that. If it's delivered to me, and then that can be rebutted.
I agree, Your
Stolen
Honor.
the deed. I could have found it, on the ground somewhere. So, but that is a presumption regarding delivery, not necessarily a presumption regarding intent. Correct?
Correct, Your Honor. I do think delivery would somewhat speak towards intent, though. I think delivery is what effectuates the conveyance of the property.
But it is required to convey the property.
Yes. And
So that I'm clear on your position is whether it's actual delivery or constructive delivery, intent can still be at play.
yes, Your Honor. And I think...
And the appellant doesn't really challenge the trial court's taking of evidence of intent. I mean, it seems to me that if the question is actual delivery creates some sort of super presumption or a conclusive presumption, then the evidence as to intent would properly be objectionable. And yet here, everybody seems to agree. The court has to make a determination as to what was the decedent's intention at the time he delivered the deed. Now, there's no dispute it was actual delivery of the deed.
No, there's not.
The question that the trial court resolved is, was he really intending to convey this property as part of the deed, whether it was recorded then or 10 years later, or was he reserving the right to change his mind?
I agree, Your Honor. I think the grantor, Mr. Chestag's intent is the poll star, which determines whether there was a valid conveyance or not, whether there was delivery. And I believe the trial court was provided competent, substantial evidence to support such a finding. James v. Mabee clearly shows that physical delivery can occur, but intent can still override that presumption. The facts in James v. Mabee are very similar. You have physical delivery to the named grantee on the instrument, like we have in this case. You have the grantor leasing out the property to third parties, like we have in this case. And you have the grantees on the instrument not questioning a single thing that happened during the grantor's lifetime. And I believe it's logical for
the grantee is paying taxes, although there's some evidence that it may have been a loan of money to him or covering his debts for him.
There was evidence on the record at trial that Mr. Chestag did not keep any private bank accounts. He would, however he got his money, he would put it into other people's bank accounts. So I think there is questions whether Ms. Robinson was advancing her money or advancing money that Mr. Chestag gave Mrs. Robinson. And there were also several other parties who paid taxes on that same property. It is an unusual scenario, but I think the trial court gave the proper weight to how much that really infers that she thought she had control or not over the property. She did not take ever any tax deductions for the property, and really I think there was some doubt of the source of the income used to pay the taxes. And that's part of the evidence that was presented to the court, along with, as Ms. Sharp said, that Mr. Chestag claimed that it was his homestead, kept the taxes in his name. She paid the taxes, under her check, but it was still paid under his name. kept his personal property there, and all of these actions taken in their totality of the circumstances, which is how the Supreme Court in James v. James says that these conveyances should be measured, how they should be determined. It's the totality of the circumstances. I do think there was sufficient evidence before the court to uphold the ruling that Mr. Shestak did not intend to make any kind of transfer at that time, that this was a separate writing which was referenced in the will, also executed on June 24th, 1999. And I imagine that the reason the courts reached this ruling to kind of carve out an exception to just making physical delivery conclusive is that the common public might not know what an execution of a deed might accomplish, that it should be the intent of the grantor that is controlling, not whoever holds the deed.
One of the issues that I think is a little bit troubling was issue 4, which is the payment of real estate taxes. And it seemed like you are agreeing the court could have awarded the appellant the amount of monies that the appellant paid for the taxes, but you also argued that they didn't file any sort of counterclaim or affirmative defense relating to it. So I guess I'm trying to get a handle on your position. Are you saying the court could have done it even in the absence of that pleading, or are you saying the court legally couldn't award those taxes because there was no pleading requesting it?
I think it was discretionary at that point. The fact that it was never raised as an affirmative defense or counteraction of any kind, I believe the case law dictates that the trial court is within their discretion to deny any kind of claim for set-off or affirmative relief for payment of taxes. On top of the fact that it wasn't pled, so there really wasn't a basis to award those type of...
And you said it was a dispute. There was some dispute as to the source of the funds.
Yes, Your Honor. And that's the second prong of why I think the trial court might have used their discretion to deny any type of set-off, is the fact that the evidence presented to the trial court raised serious doubts to where the original source of the income came from to pay these taxes. The taxes were paid in Mr. Shestak's name. Ms. Robertson may have advanced checks on his behalf, but the evidence also showed that Mr. Shestak did not maintain any type of account. Why he did that, I really don't have a good answer for that, but he would generate his income and would deposit it with Ms. Robinson or whatever girlfriend he had at the time. It would go into that account. So I do think there were serious questions as to the source of the income. It very well could have been Mr. Shestak's income being used for these purposes. And taken together with the fact that it wasn't pled and there's questions concerning the source, I think the trial court was within their discretion to deny any type of set-off. And our client, Ms. Angela, as personal representative, is also a party who paid taxes on behalf of the estate. So it wasn't just the appellant in this scenario that was advancing taxes on the estate. There was questions concerning the property, and I believe everyone, at least post-death, advanced taxes at their own risk.
Including the law firm. I think the appellant's law firm paid some taxes.
Our law firm, the Appellee's, yes, Your Honor, at our own risk. In summation, I believe that the lower court's ruling should be upheld because they applied the correct standard of law. The case law is clear that it's the grantor's intent that controls, and I believe there was competent, substantial record or evidence on the record that would support their findings. Is there any other questions I can answer? Thank you very much.
Thank you.
Thank you.
And I did actually consult a Latin major on the pronunciation
Oh,
of that
is
word.
right? So we can take that
I
as
was
the-
worried
okay.
about it. The language in the cases does actually say delivery of the deed, not delivery of the property, or intent to deliver use of the property, or relinquish control of the property. It's to relinquish control of the instrument, and that's something that is misstated in the order that was before the trial court.
Are you talking about paragraph 5 of the order when the judge said the deed was executed in a testamentary nature without any intent that the property be conveyed at the time of the execution?
That the property be conveyed, right. And it talks about the intent to give up control of the property, not the instrument. And there was also in paragraph 6 where the court, the last sentence says, no parties claimed an ownership interest in the property prior to the decedent's death, which results in the deed being ineffectual to convey ownership interest in the property for one of delivery. So, you know, my argument is that it's a de novo standard because the court was misapplying the law. That's not the law under any standard, that if you do give someone a deed, that if nobody claims ownership in the property, the deed is ineffectual. I mean, that's just not the law. So I think the court misapplied the law. And again, I think Judge Northcott was hitting on what I was saying about when you have actual delivery, yes, there is a rebuttable presumption. Somebody broke into the decedent's house because they passed away, and, you know, a sister or someone went in and found the deed somewhere and took it.
When you have possession, there is a presumption that there has been delivery.
Correct. And in this case, there was no evidence. It is unrebutted that actual delivery occurred.
You need the presumption of delivery because there was no question that he had delivered.
Correct. And we actually, in this case, found his words from 2004. If there was any question to what he intended, I think they claimed he was trying to defraud creditors, which I brought up a case and said, if you're trying to defraud creditors, the deed is valid as between the parties. You can't use that. I mean, there were sheriff sales and everything going on. They found that they couldn't go that route because if they showed that his intent was to defraud creditors, then, you know, they're going to lose, because he can't go back and get the deed back and say, well, I only did it because I was trying to defraud creditors. They tried to claim that there was an escrow and that he only gave it to her in escrow because, you know, or maybe there were some conditions on it and that's why she didn't record it. Well, that doesn't work, because I cited cases that say if you deliver it to somebody in escrow and you give it to the person, that there's no third party being an escrow agent, that it is delivered to the person. So they couldn't go that route. So the one they went with was the testamentary intent. So I would argue that almost as a matter of law, if you go in arguing different theories of what his intent was, how can you rebut a presumption that, you know, he did actually deliver the deed? In the Maybe case that they're relying on, one, it's a first DCA case, but two, they actually had direct evidence from, I think, 3 different witnesses of what the intent was, actual statements, direct evidence, not circumstantial evidence used to try to rebut a presumption. And that case was also more like a sale of land.
The delivery was to an agent of the grantee with instructions to hold it.
In that case, because there was a company and a person. So yes, and there was another case, and I don't remember which one it was.
The delivery was to an agent of the company, not to...
Correct. And there was a case, and I don't remember if it was that one, that talked about the difference when you give it to an agent of the company or the offices are distinct from the company, then that can create an escrow. But it was also more like a vendor-vendee relationship, and there's another case that talks about that, and it says, actually in the James case that sets out the standard, it talks about, while it has been decided that delivery is as indispensable to the validity of a deed between members of a family as between persons unrelated, and it goes on and says, yet it has been recognized that presumption favoring delivery is stronger in transfers like the one we are considering than in ordinary cases of bargain and sale. So, and I think they cited another case where there was a bargain and sale where somebody took a deed because there was supposed to be some later payment, and that later payment doesn't happen, then that deed, you know, you can show that that wasn't the intent to have the delivery because there was a condition. It was more like a sale of a property, not just a handing of a deed. But again, in this case, if there was any question on what his intent was, again, we came in with the presumption. We found evidence during discovery. You know, thank goodness they served discovery that made my client dig through her closet and found that piece of paper that he had written to the tax collector saying, I deeded this to my friend Diane Robertson years ago, and he signed it. So I don't know what clear evidence you could have of his intent that he knew that he deeded that property, and I think that letter was written in 2004, obviously while he was still alive, of what his intent. So to go back now, 10 years later, and say, and back in 1999, we don't think he had the intent to deliver because either fraud or escrow or testamentary, pick one, the court picked one. But I don't think that that rebuts the presumption of the actual delivery. But again, it's actual versus constructive. And if you read the cases carefully, they talk about actual delivery is not always required. And then they talk about when you look at intent. So I agree, actual delivery is not always required. In this case, we happen to have it. And I think that's what sets us apart from a lot of the constructive delivery cases. And I've already distinguished maybe. So.
You're out of time, Ms. Sharp.
Yes, and I would just ask that the court reverse judgment and quiet title in favor of the defendants.
Okay, thank you both very much. We are adjourned.
What? I don't know. I don't think you do unless you file it.